All right. Ms. Newell, anytime you're ready.
Thank you. May it please the court. Erin Newell, along with Florida Appeals, I represent the appellant Cody Hayden. May I reserve 4 minutes for rebuttal?
Absolutely.
Thank you. The second amended supplemental final judgment should be reversed, and the trial court should be instructed to deny the father's petition to modify timesharing for 3 reasons. First, the father failed to allege and show a substantial, material, and unanticipated change in circumstances. Second, the modification that was ordered turned on the guardian ad litem's sudden change of heart about the children's expressed desires to have equal time sharing with both parents 2 weeks before trial. And third, the parties' agreed parenting plan adopted by the final judgment did not provide for an alternative standard or specific facts or events to permit a modification after the final decree became final. Starting with the third point, the parenting plan. This court reviews de novo the parenting plan as it would any contract. The subject language can be found in the appendix at page 49.
Let me flip that, Ms. Newell, let me flip that instead. Let's just start with your very first issue, because I think it all stems from that. You're taking the position that the court impermissibly somehow lowered the standard for modification, but help me out. Didn't the marital settlement agreement that both parties all agreed that there will be a lowering of that standard?
The exact language of the agreement that you're referring to, Your Honor, is on page 49, and I'll quote it directly. The parties agree a significant change in circumstances will not be needed to modify the parenting plan. So what the parties agreed is that there is no significant change in circumstances needed to modify. There's no subsequent sentence there stating what was required to modify the agreement, and that's the problem here. What the trial court did in attempting to enforce the language of the agreement is it pulled the best interest standard out of section 6113 because there was no other standard for it to work with. So what the trial court effectually did is walked into this petition as if it was an original decree. And that's exactly what the Fifth District Court of Appeal did in Wade. When Wade came to the Florida Supreme Court, there was uncertainty regarding what would be necessary for the movement to qualify for a modification of a child custody decree. You had the Fifth District on the lower end of the spectrum, right? Requiring the movement to only show that it just wasn't working out. Okay, at that point, if the movement can show it wasn't working out, the trial court could come in and employ the best interest standard as it did in this case and make a determination as if it was an original determination. We had this court, the Second District, actually on the highest end of the spectrum, along with the Third District. And this court required not only a substantial, material, and anticipated change in circumstances like the first, but it raised even higher the bar to require a showing that the original arrangements for child custody were detrimental to the child. Okay, so this court was at the highest end of the spectrum. What the Florida Supreme Court did in 2005 was come to a middle ground with the First District Court of Appeals substantial change test. And that is a 2-pronged test that requires first, of course, the substantial material and unanticipated change. And then the court can look at whether the modification would be justified based on the best interest of the child. And it's very important that first prong is necessary in order to meet the burden of overcoming the res judicata of the original decree. And that's what this case and Wade really are about. It's about the parties agreeing to an original parenting plan, which they did in this case. And the parties in the parenting plan state, this is at page 16 of the appendix, their abiding and unwavering opinion that the parenting plan and time-sharing arrangement is in the best interest of our children. So that's incorporated into the final decree, and that becomes the res judicata. In order to overcome the presumption of reasonableness of that, the movement must come to the court with some factual basis to justify and warrant a modification. Now, Wade does recognize that in footnote 9, that a final judgment may specify circumstances that will later justify modification. And that's what the appellee relies on here, that the parties can agree, well, you know what, we're going to agree that we're going to be able to modify this later down the road if a certain fact or circumstance occurs. The language here does not contain any fact or circumstance that's going to occur to enable modification, and that is absolutely necessary.
Is your position that that provision of the marital settlement agreement that was adopted by the original judgment is a nullity?
Your Honor, I believe what the parties did with this language cannot be enforced. I'm not sure how to answer your question. I apologize.
But did anyone appeal the judgment?
Yes, the original final judgment. I understand what you're saying. No, that final judgment became a final judgment, correct. It is not until the father tried to.
No one said, hey, it's got language here that is unenforceable.
That is correct. Yeah, it's the father who's attempting now to enforce this language on a petition to modify. The position is that this language is not sufficient to qualify under Wade as a circumstance that will later justify modification. The key and the reason why this judgment can't be affirmed in the appellant's position is that the parties can't dispense with showing a substantial change altogether or something tantamount to that to overcome the res judicata of the final judgment. This court had occasion to employ that principle in Blackburn in 2012. The Blackburn decision dealt with a magistrate recommending that certain language be incorporated into a final judgment, which would allow the parties to modify if it didn't work out. Excuse me, there was a fly. But this court looked at that language and held that that could not be done because of the res judicata of the original decree. The modification cannot occur freely at will of the parties. More recently, in Idelson versus Kramer, that's a 2021 case, we had an actual marital settlement agreement. Language in the marital settlement agreement did contain a factual basis. The factual basis was the third birthday of the minor child. It was stated clearly it was an event that could occur. It did occur, and the parties were allowed to incorporate the child. This court affirmed that part of the judgment in Idelson. However, the part of the judgment that effectuated additional modifications beyond that one precipitating event and that child were not affirmed. This court reversed that portion that effectuated modifications without a showing of a substantial, material, and unanticipated change in circumstances because there were no factual bases established in the parenting plan to do so. The father's interpretation of this language in this appeal as actually replacing the substantial change test with the best interest test is not sound from a construction standpoint because it requires this court to tack language onto the sentence. The sentence simply states a significant change in circumstances will not be needed to modify. First of all, it doesn't identify Section 6113, which was amended in 2009 after Wade to prevent modifications without showing a substantial, material, and unanticipated change. So it doesn't even refer to the proper standard, which is the substantial change test. And then beyond that, there's no mention of a replacement with another standard. The best interest standard is not mentioned at all in this entire parenting plan for this particular section of modification. So the interpretation that the father is asking this court to do would require this court to tack this additional language on in order to clarify. Yes.
Isn't the best interest standard always in effect? I mean, you don't get a modification just because there's a change in circumstance.
Certainly, Your Honor.
Right. So isn't it arguable that eliminating the substantial change requirement in this agreement then left standing the best interest requirement of the law?
So I think your question has two parts. First, I want to address that you said eliminating the substantial change requirement. So this language does not eliminate the substantial change requirement from a first
substantial
point.
change will be required for a modification?
It's not. It says a significant change in circumstances will not be needed to modify the parenting plan. And words have meaning in the law, and the substantial change test, particularly for decades, has had a very specific meaning in the law. However, assuming that it did say a substantial change in circumstances would not be needing, I will answer the question in that manner. Yes, there's always the best interest of the children that are going to guide the court. However, the point is that we're here on a modification. A petition for modification carries with it a very specific burden of the movement, and that's that first prong. The reason the first prong exists. Yes, Your Honor.
This provision can only apply to modifications, correct? I mean, by its
Correct. By its terms, it's titled Changes or Modifications of the Parenting Plan. It's specifically talking about modification. And in order to, sorry, go ahead, Your Honor.
So tell me what you think the effect of that language in this agreement is.
The parties may have been trying to not have to show a significant change in circumstances to modify the current parenting plan. If I'm reading the plain language as we must, it states the parents agree a significant change in circumstance will not be needed to modify the current parenting plan. So by the plain language, they were attempting to agree that they don't have to show a significant change in circumstance. The fact of the matter is, Wade requires as a matter of law, and so does Section 6113, not only that there be a substantial, but also a material and unanticipated change in circumstance. So again, the reason for this first prong is to overcome the res judicata of the original judgment. That's why this first prong is so important. You don't get to the second prong of this test. You don't get to the best interest without satisfying the first prong. And many cases since Wade have held that, and these are cited in the initial brief. Without satisfying that initial burden, the movement does not get to argue the best interest. And the reason that is because the best interests have already been adjudicated. The res judicata of the final judgment must stand. If we're allowing parties to come in after a final adjudication of child custody has been made and simply re-argue, it's destroying the res judicata and the finality of child custody awards, and that is a dangerous precedent to set. Moving on to that first.
Isn't it a more dangerous precedent, Ms. Newell, if the court does not honor the parties' agreement? I mean, this is sacrosanct. Parties could agree, enter in a contract waiving all sorts of things. And so wouldn't that be bad if we somehow say, oh, the parties agreed, oh, no, I don't think they really meant it. So this would be equally bad.
I understand your question. And I think if this language were different, we'd be having a different conversation. What the parties actually agreed to do here is not to replace the substantial change test with the best interest test. There's no language in this agreement stating that. There's no factual basis or precipitating event that the parties have agreed to enable to justify and warrant a future modification. Had the parties crafted their agreement more carefully and identified those specific circumstances, then I agree with Your Honor. There is a specific ground that the court must follow. The parties have set forth this agreement. They've agreed that this event is going to warrant a modification, so we must enforce it. But the parties didn't do that here. That's the problem with this language. And Wade requires, as does 6113, the law is what the law is. The parties are charged with knowing that at the time. This language is not sufficient to fully excuse the substantial, material, and unanticipated change test of Wade and 6113. That's why the judgment must be reversed. The order on appeal does not make any determination regarding whether there was a substantial, material, and unanticipated change in circumstance. It just skipped to prong 2. As I've noted, that is reversible error. But we're asking this court to instruct the trial court to deny the petition on remand because the father actually did argue in closing argument that 5 circumstances constituted sufficient grounds for modification. The father's argument, as well as the mother's throughout this trial made it very clear that there was no stipulation between the parties that this agreement was going to be interpreted as, employing a best interest standard rather than a substantial change standard, by the way. The mother did not, there's no interpretation whatsoever or colloquy during the trial as to what this language meant. And the court actually asked the parties to explain as a housekeeping matter in the beginning of trial what this pretrial stipulation was. And the father's counsel answered, that is actually language directly from the parenting plan. So there was no separate stipulation. There was certainly the trial court was not under the impression that there was a stipulation, as it discussed the substantial change test at length from pages 1486 to 89. And this is also laid out in our initial brief at pages 6 through 7. So as an initial matter, and as the father's own closing argument shows, they were still arguing about a change in circumstances here. The 5 circumstances that the father suggested could justify change were his living circumstances, his contact had been cut off, that was previously liberal, the children were sharing a bedroom, they were struggling at school, and the mother undermined the father. None of these circumstances, as a matter of law, are sufficient to meet that high burden that applies in this case. For that reason,
you are in rebuttal time. So
I appreciate that. Because the father was not able to allege or show any of these circumstances are substantial, the trial court should be directed to deny his petition on remand. I'll reserve the rest of my time. Thank you.
thank you. Mr. Park, you're up.
May it please the court, I represent the appellant. I want to address, first of all, one of the most recent statements opposing counsel made, that there was no discussion or stipulation about the impact of the language in the parenting plan. And I'll direct the court to the mother's own counsel talking about this, and I quote, and Your Honor, I was just going to add that I may argue that a little bit throughout the trial, realizing that the parenting plan does waive, and the parties did waive, the substantial change in circumstances requirement in their parenting plan, just for appellate purposes, Honor. So if I do bring it up, I acknowledge the fact that it is in the parenting plan, but I just want to preserve the record. There was no dispute throughout this case.
Mr. Park, and if I may, and actually the court indicated that in the second amended supplemental final judgment. It recognized that fact, indicated that, made reference to that agreement. So that's clearly laid out by the court, correct?
Yes, ma'am. And in fact, in the pre-trial court order, I think of April 12th, if memory serves, the court puts right in there that the parties stipulated that they were waiving the substantial change in circumstances test. When I first read opposing counsel's brief, I was trying to figure out what the crux of their argument was. It appeared initially to be that substantial and significant were not functional equivalents. And in the plain reading of this contract, I would have to argue that they are. I think that that's what Ms. Patelis indicated to the court. I think that's what the court understood. That's what the husband understood. And that, getting back to Judge Northcutt's discussion earlier, if you look at Wade, which I don't disagree that ordinarily, if there is no parenting plan that's agreed upon, if there's no settlement agreement, and this is purely the court determining contested issues, that the court does not have the authority to modify the test under Florida law to be just the best interest standard. I fully agree with that. The problem is all the cases cited by opposing counsel are in situations where either it was a contested hearing and a final judgment entered by the court, or there were no discussions in the parenting plan that was agreed upon by the parties to modify the change. So if you look at Wade, as counsel urges you to do, you have a two-pronged test, which is mirrored in 6113, subsection 3. And it says basically the first threshold in a modification is, has there been a substantial change in circumstances? If you get over that threshold, you then turn to what's the best interest of the minor children or child based upon the factors set forth in that chapter. I would argue that we don't need to specifically enumerate the best interest test as the appropriate test to use in this, because it's assumed. If you look at the language of the parenting plan and give it the proper import and meaning you think it should have based upon reading it in context and understanding that the law of Florida in 6113 sets forth that two-pronged test, then what the parents were attempting to do was say, look, as parents all the time do, we don't want to have to come back and demonstrate a substantial change of circumstances every time we want to modify this, because in the life of kids, they grow up, circumstances change, it becomes somewhat problematic sometimes to have to go through that process every single time. So what we're going to do for the benefit of both parties, the mother could have used this as well, is to petition the court to modify it based upon the best interests of the minor children. And I would argue that that's actually a better standard to use in this particular case with minor kids, especially if they grow up, because you can more freely track with their best interest. The parties knew what they were doing. They specifically waived that. They waived it in the section regarding modification, and to try to now suggest that that's not what it meant, I think is a little disingenuous, especially given the fact that throughout the case, they agreed and stipulated that's what the language meant. Moving to some of the other arguments, Judge Kazam, I think you brought up an excellent point with regard to what kind of effect would this have if you were to reverse this based upon the argument. Florida law allows parties to contract unless a contract is either void against public policy or illegal. And in this case, there's really been no argument as to either of those conditions for this. They just simply say that, well, we shouldn't enforce this because Wade says you're not allowed to do this. My brief, I believe, set forth many cases which, including in this circuit, state that, or district, that you can modify the test for purposes of a modification. And that's something that's done routinely. And the public policy that I would be concerned about is the parties negotiated this very specifically. And if you were not to allow parties to waive a substantial change in circumstances test, then you would potentially create a situation where the parties will be less likely to agree to time sharing in a mediation, because they will be concerned that even though, you know, I might agree to this right now, that I will be hamstrung by this by res judicata and not be able to modify it down in the future. The fact of the matter is both parties in the mediation agreed, hey, we want to have the freedom to go to the court in the event that there is a situation where the best interests of the minor children necessitate a modification. And both parties had equal opportunity to do that. I would dare say if the situation was reversed and the mother was awarded time sharing or relief, that she would be arguing the exact same thing. If we hold to the appellant's position, then the parties are in a situation where they negotiated for a lower standard, probably to allow them to agree to a time sharing amount that otherwise may not have been agreed upon, with the idea being there is a lower standard to modify it. So if it doesn't work out, we can go change it without having to show a substantial change in circumstances that's unanticipated, permanent, and all the rest of those things. There is a specific negotiation for that very language, and to now suggest that it is a nullity or it's unenforceable, I think is very problematic, not only for this case, but for many other cases where parties need the freedom to be able to address time sharing in a more flexible fashion. Getting back to the language, I think there was an excellent question to opposing counsel, which was, well, is this a nullity? What language or what import does this language have? And that question was not really answered. The answer really is, if you take out the waiver of the substantial change in circumstances prong, the language effectively becomes a nullity. And there is nowhere else in this agreement where the parties have simply recited existing Florida law, which is essentially what Ms. Newell is arguing, that, oh, well, they just put this in there because it's consistent with Florida law. If you were to take out that significant means substantial language, and they don't do that anywhere else. They intended to put this in for a very specific reason. They negotiated for it and they both agreed upon it and abided by it for years. And I believe this final judgment, and this thing was entered in 2017, if memory serves, which was long past Wade and the codification in the Florida statutes. So both parties knew exactly what the law of Florida was, and they intended to modify the standard because of their agreement in the settlement agreement. Getting to some of the other points with respect to a couple of the other issues that the mother brought up, there were plenty of findings in the trial court's final judgment, amended final judgment. 11 pages of single space findings. As this court's well aware, Florida law does not require a trial court to set forth every factor in 6113 sub 3. It simply requires them to consider them. And in this case, not only did the trial court consider them, it made detailed findings and ultimately determined that based upon the best interests of the minor children, the modification to the time sharing was warranted. The mother suggests that somehow all of these factors were either in her favor or neutral, or somewhere they were even, and that the guardian ad litem somehow tipped this over. First of all, there's nothing in the supplemental final judgment to suggest that. The court simply says it weighed all the factors, made the findings, and said based upon the best interests of the child, modification is warranted. There's no suggestion that all the factors were equal or weighed equally. And in fact, there's no case in Florida that says you look at those 20 factors, and if 15 of them go for mom and 5 go for dad, you automatically go for mom. It basically is a situation where you look at the factors, you weigh each of them depending on a case-by-case basis as to the impact on that particular case. And you might have a situation where the majority go for one party or the other, but the court decides for the other parent because of the impact of those particular things. For example, one of the things is, whether or not there's been abuse or violence or something like that. That may have a much heavier weight to it, to a trial court, than something like, the preference of a child. So just because the majority or the numerical total goes in favor of one party, there's no case law to suggest that's the appropriate standard to use when determining which parent should have the majority of the time sharing. And there was nothing in this final judgment to suggest the court did that. Effectively, the position of the appellant requires this court to violate the clear construction standards that we all abide by, which is if you have the plain meaning of a word, you apply it. And I think even Ms. Newell agreed. The plain language here says they're waiving the substantial change in circumstances. I know she said significant, but I'd argue those are the same thing. And secondly, it does violence to the whole concept under contract construction that you have to give import and meaning in context to every single phrase. And I think she would agree, or at least in her opening comments, kind of subtly agreed, that were you to adopt her interpretation, that language, that sentence effectively is eviscerated and has no impact whatsoever. And so if you look at the context of the language, you look at the terms agreed upon by the parties, you look at where it was in the agreement under modification, you look at the language used, whether it's substantial or significant, both are functionally equivalent. And as I put in my brief, even the law dictionary says that defines substantial as significant and significant as substantial. You would have to determine that the parties were intending to waive the substantial change in circumstances prong in order to get to the best interests of the minor children. And therefore, based upon that, the trial court should be summarily affirmed, in my opinion. And in the future, if things change, it could inure to the wife's or mother's benefit to modify it based upon a best interest standard as opposed to a substantial change in circumstances. So the kids are the true winners in this case with the language, not the parties. And the court will continue to have the opportunity to track the best interests of the minor kids as opposed to the legal, wranglings of the parents. Unless there are any other questions, I'm finished.
Thank you, Mr. Park.
Thank you.
Ms. Newell, you're up.
Thank you. Beginning with the notion that the legal wranglings of the parents would get in the way, it discounts the actual language that we're talking about here. If we look at this section titled Changes or Modifications of the Parenting Plan, the first paragraph addresses modifications that can be made by parents agree in writing, right? That is effectuating what Mr. Park is discussing, where there are certain things that occur in the course of the children's lives that the parents are going to agree, look, this is for the kids, we're going to agree in writing, it's all going to be good. But the second paragraph requires the parties, through the filing of a supplemental petition for modification, to come into the court. That is where the threshold applies. Mr. Park is advocating for the court to be able to freely look at the best interests of the children standard here. 11 pages of findings as if this court was making an original determination, as if the original decree of child custody never existed. And for what? What allowed the court to do that? There must be a threshold, as the Appellee's Counsel recognized. There must be a standard. Appellee's Counsel recognizes and agrees that the court does not have authority to modify a final decree of child custody just based on the best interest of the child standard. He stated that in his argument. Okay, the appellee's cases that he referenced in his answer brief also all occurred before Wade, which is important. Wade steps in, it clarifies that the res judicata of the original decree must be overcome by a factual showing that is tantamount to a substantial change in circumstances. Throughout this argument, not one of us have referred to this standard as a, I can't even say it, significant change in circumstances. It doesn't make any sense because substantial change in circumstances is a term of art. It's the test that we use to discuss modification.
Well, I remember, people talk about Wade a lot, and I remember it pretty clearly because I was quite surprised by what Wade did. The issue of whether, there had been a supposed split in the district about whether you had to show detriment to obtain a modification. I know Mr. Park agrees, remembers this, and you might as well, Ms. Newell.
Yes.
But that issue was never before the court. It wasn't briefed. It wasn't before the lower DCA. The issue that went up was whether a petition to modify a modification of an equal time sharing arrangement was a modification or a new, what was it, a new custody determination or a modification? Saying that you had to have substantial change of circumstance and best interest of the children was nothing new that Wade said. Wade said, you don't have to show a detriment, but it did say, unless the judgment says otherwise, you have to have a substantial change. And here we have a judgment that incorporates an MSA that says you don't have to have one.
Your Honor, if you look at Blackburn, you also had a judgment that said that. You said the parties are freely allowed to modify. It's the same concept. Blackburn's a 2012 case out of the Second District Court of Appeal, where this court said you cannot impose that type of open-ended, freely at will modification. That's exactly what Blackburn says. Whether it's through the agreement of the parties or the decree of the court, the effect is the same. It's purporting to allow a modification of a final custody.
Yes. You're trying to accomplish a modification of the original judgment by essentially eliminating that provision.
I'm sorry, can you ask the question again?
Are you not attempting to modify the original custody determination by having that provision dispensing with the substantial or significant change eliminated? Are you not trying to do that? And if so, what is your substantial change of circumstances that you rely on to accomplish that?
Your Honor, I don't agree that this is attempting to modify the language of the agreement. We're certainly discussing the custody, the parenting plan, and the custody of the children. So there's no attempt at that. I understand your question. You're saying we're trying to change the language that the parties agreed to in that provision, but we are not. The parties, it is incumbent on the parties to employ the test that they wanted, and they failed to do that. As Wade says in footnote 9, there have to be specific circumstances designated by the parties. Wade is the default. 6113 are defaults. Those are the standards that apply in lieu of the parties agreeing otherwise. The parties simply didn't get there here. For those reasons, the wife asked the trial court to dismiss the petition from the outset for failure to allege a substantial material and unanticipated change. The wife pled in her pleading that there were not circumstances sufficient to justify a modification, and in her closing argument, again, asked the trial court to deny this petition for failure to establish a substantial material and unanticipated change in circumstances. The wife is asking this court to reverse the modification order and remand with instructions that the trial court deny the petition.
Okay.
Thank you.
Ms. Newell. Thank you, Mr. Park. In order to get out of our virtual courtroom, you click the button on your Zoom screen called Leave, and you will leave and go off into the ether. Okay, and with that, we're adjourned.